So in one day, you're saying he made how many calls?
28 calls to the complainant's phone.
Well, Judge,
Phone calls.
this would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness. Hey,
We're here on Mr. Wiggins. I'll let him.
something else happened?
So, Judge,
No.
he has been consistently calling the complainant from the VPO from jail. I believe at last check on Friday, it was since March 26th, it was 130 times or something like that. Yeah. So
Back in.
Well, he's in
He's
custody.
already-
He's in custody.
Oh, ag seg. Goes in ag seg. Okay, so guys, for the record, please announce yourselves. State.
Anna Edie, EADY, for Mr. Wiggins.
Nathaniel Meunier spelled Munier, also for the defense.
State. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO. Since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
My understanding is that there's no longer a protective order in effect because it's been long enough that the protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
He is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken
I
the
have
law.
ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Edie talking to me today, it sounds like that the court was going to order ag seg in the jail, so the formal
The only
term-
way that we can revoke phone privileges on someone is ag seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond, thus no crime has taken place. And third to that, Judge, if he's to move to ag seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies and
The
not
only
being able.
way, but okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate. Letters, in person, but the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to be called, including our office as well as his felony attorneys. Letters through the jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the
But-
problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms
It's not
there.
about me, Judge. It's about felony court. It's a serious issue, but that's the.
Why are
fifth
you
thing.
worried about felony court?
Because that's why he's in, Judge. Then
Well,
that's
it's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is, and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is.
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry,
But
Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him in
So
another wing.
I was going to talk with the DA, and obviously if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge, strict scrutiny dealing with
I have
constitutional rights.
no other way to prevent him from making phone calls. I have acquiesced to you guys before and I've admonished him before, please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not gonna do it, I'm not gonna do it. And now we have 300 phone calls. So I don't know what else to do, but now we're back in Act Seg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them, I just have to get I have to do the form, so I get them up with the forms, yeah.
Okay, so let's set up a formal hearing because I don't want, you're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they
Mr.
can join
Wiggins, I'm
in our
going to have
motion.
you sign an affidavit from me today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of ag seg. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules, et cetera, et cetera.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? We'll have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
In the last time, he used someone else's SPIN number to make the phone calls.
That was last
So,
Yeah.
well, we'll see this time. I don't know. Okay, all right.
Just for the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. Do you understand?
Sure.
Okay.
You were charged with theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. I have no idea what happened on this case. All I know is that you've been charged with a Class A theft. I've appointed you a lawyer with Mr. Dixon now. We're going to do probable cause to see what actually happened. Please.
On January 5th, 2025, the complainant reported that his church mailed out checks for payments to various utilities with multiple checks that were then stolen. After being assigned the case, the officer spoke with the complainant, who stated that he received back his bank statement, which reported the following checks being stolen. The first check for $780.20, which was drawn off his.
Oh, I remember this. There's like several different people that are,
Yes, so there's multiple checks. The next check is for $780.40. The next check is for $784.09. That was to a Mr. Tinkham, who reported that he didn't know the individuals and did not give them consent to endorse or cash any of his checks. They then subpoenaed the bank records and showed that the checks were changed to pay Sonia Ferris at the Chase Bank at 1520 San Felipe Street.
do we have it that she actually negotiated the check and put the in her account?
Are there any complete readings?
I have to figure that,
Yes.
banks, I mean, there are cameras everywhere.
And
right?
may you please ask her
Yes,
what
the
date?
teller job log journals indicate that the person casting the check presented a Texas ID as the primary identification source. The officer then checked this identification through the Texas driver's license database and found that it was associated to.
What was the date of the transaction, may I ask, state? Because my client has been incarcerated. She hasn't been,
2023, believe it or not. Yes.
What is it?
On April 12th, 2023.
April 12th, 2023. Okay. So, Ms. Ferris, I'm going to find that there's sufficient probable cause to go forward with your case. So then too messy.
I was in the way.
we'll get there. I just wanted to make sure that it wouldn't be on the time that you were incarcerated.
April of 23, 22, April 23rd, I got out of the way.
Ms. Ferris, as a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case. That is, I guess you said a church, right? Or the person who is associated. So you're not to have any contact with the actual church and the person who is the owner of the checks. I'm also ordering you as a condition of your bond not to have any contact with the co-defendants in this case as well. If I find that you pick up a new case, if I find that you're a danger to my community, if I find that you break these conditions, then same will happen to your bond. I will revoke it, put you in jail, no more PR bonds. Do you understand?
I do.
I've given you a lawyer. It is your responsibility to stay in touch with Mr. Dixon. If he tells me that he can't get a hold of you because you're ducking and dodging, likewise, a warrant will issue.
Sir.
Guys, we have to set a bond on this case. So what bond? What do you think? State. What's appropriate? And is a PR bond appropriate in this case in light of that she's on felony probation for a third-degree felony?
We asked for $5,000 charge.
Judge, I would respectfully ask a PR bond on this case. The probation officer, the CS community supervision officer is here. Mrs. Ferris has been diagnosed as being bipolar with psychotic tendencies. She was on cocaine, ecstasy, and other major drugs, but she was determined to be competent. Right now, she is not free. She is not free. She is in custody with the in-house.
Oh, she's in DDRP.
Yes, sir. She's in DDRP at this time.
So I have to give her a PR bond.
Yes, sir.
Because if I take her into custody now, that kind of ixnay on the DDRPA right?
And her felony court's aware, we did a case review and they want her to continue treatment, finish it successfully.
And I always want, it's okay, don't worry about it, I always want that as well. You know, we want you to complete the treatment. It is also a condition of your bond that you're not to use alcohol, illegal drugs, and I'm going to test you like crazy to make sure that you're not using. Do you understand?
I do.
Okay, so I will set the bond at 5,000 and then I will grant her a PR bond.
Thank you, Your Honor.
Case number? It is 255-0584. Thank you. Okay, so for now, I'm going to have you sign a reset with Victoria. We will also have you meet with Felicia for your bond conditions. We'll have you sign the bond conditions. Do you have a date of release?
Yeah, I can look right now.
Yeah, do you know mind if you can provide it to Mr. D? That way we know we can set her case for the day after. That way we can get here to be able to monitor her with everything. Okay, all right. Good luck,
Thank
Ms. Ferris.
Thank you.
Okay, thank you, Mr. D.
For Ms. Ferris, can we go over those again?
No alcohol, no drugs, random UA, no contact with co-defendants, no weapons, no contact with the church, or no contact with the person who's, I guess, either the owner or the money. Okay. Good morning, Mr. Diaz.
How you doing?
So you're charged with possession of a controlled substance. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand, sir, that this is going to go on your record. It can be used against you anytime you pick up any new cases. You will now be facing a minimum of 90 days in jail. It looks to me that you're also on felony probation. Is that right?
Yes, sir.
You need to understand that this can, by pleading guilty to this offense, this may result in that probation being revoked, resulting in further confinement. Do you understand?
Sir.
Do you still want to do this?
Sir.
How do you plead to the offense of possession of a controlled substance, guilty or not guilty? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never come back and change this. You understand?
Sir.
You're on felony probation. There's only so many times they're going to bend over before they, put you in prison, man.
Sir.
You know,
I don't want that.
don't say anything, but really, the more you pick up, the worse it is. All right. All right. Good luck.
Your Honor, good seeing you. Have a good day.
Online, digital, business.
Hello? Sure. And? Okay, zoom back on. Do you mind? Please, thanks.
Huh? Gonzalez?
Okay, give me a second, Dion.
Yes, sir.
You are Vincent Rodriguez.
Yes, sir.
Mr. Rodriguez, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor, so you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 9-month deferred. So he's got 2 cases. He's got the criminal trespass and this case.
Correct. And they're going to be dismissing the newer criminal trespass case.
Is this what